We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the May 13th session of the Massachusetts Appeals Court. My name is Mary Sullivan, and together with me today are Justices Eric Nyman and Catherine Hand. We will be your panel for the day. The usual rules of oral argument apply. 15 minutes per side, no rebuttal. You can assume that we are well versed with the briefs and the record, and we encourage you to get to the heart of your argument. We hope that we have no technical issues today. If we do, and it's necessary for us to fix them, those of you watching this on YouTube may see your screen go dark for a moment. We will come back. If anyone is currently live streaming on YouTube, if any of the counsel, it would be helpful if you would turn that off, because there's a lag between the internal feed and the external feed, and we'll get some feedback. We ask only on a technical issue that if there is a problem, we'll be patient with you, and we hope you'll be patient with us. And finally, if anyone seems to see us turn away from the screen for a moment, we need no disrespect. We are fully attentive to your arguments. It's just that we have the case materials to which we need to refer off to the side, and Zoom magnifies any movement of the head. All right, with that preliminary, our first case is 20P1124, Carney versus Provident Funding Associates. And I believe it's Attorney Durden?
Yes, Your Honor.
Okay, when you see the time go up, you may begin.
Members of the panel, may it please the court. My name is Keith Durden, and I represent Ms. Carney and the appellant in this case. This is a case about whether a mortgager wrongfully forecloses on a mortgage and breaches the covenant of good faith and fair dealing when the mortgagor fails to provide the mortgagee with the statutory required notice of her right to cure under Mass General Law 244, Section 35A. And when that failure renders the foreclosure fundamentally unfair. This case is also about whether, when there are irregularities, in addition to the failure to provide a Section 35A notice prior to foreclosure, whether those irregularities in conjunction with the failure to provide a Section 35 notice is a breach of the covenant of the good faith of fair dealing included in all contracts. And our answer to that question is yes. We argue that the court should find in favor of Ms. Carney for at least 4 reasons. First of all, Provident Funding was statutorily required to provide Ms. Carney, the appellant, with a notice of her right to cure under Section 35 before they move forward with their foreclosure on the property. 2, they failed to provide that statutorily required notice. And that failure, under the circumstances in this particular closing, was fundamentally unfair to Ms. Carney. In addition to their failure to provide the statutory notice, the irregularities in the foreclosure, which are discussed in my brief, in addition to their failure to act in good faith in negotiating with her in a loan modification, was a breach of the covenant of good faith and fair dealing. As the panel knows, the court accepts the findings of facts by the judge unless clearly erroneous.
Well, Mr. Durden, I'm sorry to interrupt you. That's a nice segue to my question, which is this. As I understand it, the right to cure notice was provided, but it was provided in 2011 on the last occasion. Is that correct?
That is correct, Your Honor.
And then it wasn't provided within the subsequent 5 years. So then our analysis at that point, at least according to Judge Wilson's findings, hinges on whether or not your client can prove that the violation of Section 35A rendered the foreclosure fundamentally unfair. Am I stating the correct standard?
Yes, Your Honor.
Okay, so here's my question for you, and that's, doesn't the judge's analysis of that issue hinge largely on findings of fact?
It does, Your Honor. And
So if so, and here's my question, because Judge Wilson issued very comprehensive findings. What findings are you pointing to that you say are clearly erroneous such that we can overturn those findings?
thank you, Your Honor. I'm not making the argument that the findings of fact were clearly erroneous. I understand that that's a very high burden. My argument, or our argument, is given the facts that were presented during the course of the trial, we believe that the foreclosure was fundamentally unfair. The facts being that Ms. Carney was at a point where she had made a proffer to Provident Funding in order to become current with her mortgage. And she was not provided with a statutory notice that would have told her exactly how much she had to pay in order to become current with her mortgage. And we're arguing, our argument is that failure was fundamentally unfair. There was a time crunch in terms of the foreclosure occurring. Had she been provided with the statutory notice of a right to cure, she would have known how much she owed, and she would have been given 90 days in which to get the funds in order to become current with her mortgage.
Attorney Jordan, could I ask a question on that note? If, assuming that your client's position is correct and the statutory notice was required, in the absence of the statutory notice, your client wasn't given the final cure figure, was there any obligation, if we look at the fundamental unfairness analysis, for your client to make inquiry about what that final amount was?
Yes, Your Honor. And we argue that there was an inquiry. The inquiry was the offer and the request for a counteroffer that showed an intent to find out exactly how much she owed. The counteroffer could have been communicated to her by Provident Funding that it was the total amount that she was owed. That Provident Funding was owed.
But would Provident Funding, if it were an offer, would Provident be expected necessarily to respond with the full amount, or could Provident have responded with some compromise amount if it had wished to negotiate that amount? Is that necessarily the same thing? I'm asking, I guess, as a request for the balance.
I'd argue that it is not necessarily the same thing. Provident Funding could have provided a counteroffer, but we're also arguing that Provident Funding had a statutory duty to provide her with the figure that she would have to pay in order to become completely current with their mortgage. And their failure to do that was still fundamentally unfair towards Mrs. Carney.
Thank you.
As Your Honor, I'm sure is aware, the material facts in this case were that Ms. Carney and her husband fell behind in their mortgage back in 2010. And as a result, they received 2 Section 35A notices from Provident Funding. One in September 30, 2010, and the other was January 3rd, 2011. They cured both of these defaults. They also applied for a loan modification that additionally cured the amounts that they owed for those 2 notices of the right to cure. Given that fact, Provident Funding was obligated to provide them with another notice of the right to cure in light of the fact that the foreclosure took place more than 5 years after the last notice of the right to cure was provided.
If we were to agree with you on that and say, yes, there is a violation on the 35A notice, but she filed, I think, fairly shortly before the foreclosure was to take place, an application as she had been invited to do, but it didn't, if I understand it correctly. It was deemed, the application was deemed insufficient because it failed to have the information from the co-borrower. Am I correct about that?
That is correct, Your Honor.
All right. So in the fundamental unfairness analysis, even if Provident failed to give her a liquidated amount, as it should have done, does the fact that her request was deficient in that respect mean that the subsequent actions of the bank were not fundamentally unfair?
Thank you, Your Honor. Given the total totality of the circumstances, I would argue that it was still fundamentally unfair. It was fundamentally unfair because Ms. Carney was experiencing difficulties in getting information from her husband, her ex-husband, who she was, in fact, was going through a divorce with at the time. If, again, Provident Funding had provided the statutory notice, that would not have been a problem. That would not have been an issue because she would have been able to, we contend, go into a fund that she had, a retirement fund, in order to get the funds to become current with her mortgage. Provident Funding failure to provide her with that opportunity was fundamentally unfair.
Could I ask Attorney Durden, just because the time is running a little shorter, to move on to the mismanagement issues for a minute? And I have one question, which I hope doesn't throw you out of order for your argument, but to ask, with respect to your challenge to the judge's determination that Mulligan was Manini's agent for bidding purposes, what was required in order to make that showing here?
I argue that there should have been a power of attorney filed during the foreclosure sale between showing that Mulligan had the authority in order to bid. There was no power of attorney. There was nothing that showed that there was a authority for the parties to be in that the parties were in fact in an agency. And our argument is that it was irregular. There was a previous, the previous bidder, Ream Associates, had actually a power of attorney that was on file. So it was clear. Here, that was not the case. We argue that given the circumstances with the timing and, that Ream Properties had defaulted on their deal to purchase the property, and these particular irregularities and Provident Funding negligence, if you will, or failure to be to dot all their I's and cross all their T's is a factor that should be considered in whether they were acting in good faith in conducting the foreclosure.
Sorry to interrupt. Is there authority that says that that's required, or that if an absence of that kind of a recorded chain invalidates the sale?
Other than to say that the power of sale inside the mortgage has to be strictly complied with, which means that I would argue that for it to be strictly complied with, all the I's have to be dotted and T's crossed, and that was not done in this case. Finally, Your Honor, we'd argue that the provident funding argument regarding res judicata does not apply in this case. Provident funding argues that during the foreclosure, because there was a motion, during the bankruptcy, after the auction took place, because there was a motion filed by Ms. Carney to void the foreclosure, that precluded her from challenging the foreclosure later. We argue that that argument does not have any merit because the motion was limited to the question of whether the auction violated the automatic stay, and it was not a full litigation of all the issues involved in the foreclosure. Additionally, the objection, there was an objection to a proof of claim that Ms. Carney filed in connection with her bankruptcy, that Provident Funding filed a claim, and she filed a objection to that claim. The claim is, the position that she took in the objection to the claim is not inconsistent with the argument that she's made throughout this case. The argument was that the foreclosure sale should not have, she concedes in both cases that the foreclosure sale took place, but in the bankruptcy matter, she argued against the appropriateness of the characterization of the claim that Provident Funding was making. We're asking the court to remand the case back to Superior Court with the finding that the foreclosure was wrongful. Thank you, Your Honor.
Thank you very much, counsel. All right. Attorney Robinson.
Morning, Your Honor. Good morning, Your Honors. May it please the court. As an initial matter, I would note that the appellant has not challenged on appeal the dismissal of count 2 of her complaint for negligent misrepresentation, and therefore any challenge should be deemed waived. The only counts remaining to be addressed on appeal are count 1 for wrongful foreclosure and count 3 for breach of the covenant of good faith and fair dealing. With respect to count 1, the trial justice's thorough decision in all respects correctly found that Providence foreclosure was proper. Ms. Carney, we submit, received all of the notices to which she was legally entitled. After she defaulted in 2010, Providence sent 2 notices of right to cure, September 30th of 2010, and again on January 3rd of 2011. The fact that the foreclosure sale took place in 2016 did not trigger an obligation on Providence part to send out a new notice. There is no expiration on the right to cure. In an unpublished decision from this court, cited with approval by the Massachusetts Federal District Court, it was held that we declined to create an additional requirement not present in the language of the statute that foreclosure proceedings must also be completed within 5 years, particularly where, as here, there is no allegation that the foreclosing entity was at fault for the delay. That is spot on with this case. Any delay in the foreclosure, Your Honors, was occasioned not by Provident as the foreclosing mortgagee, but by Ms. Carney herself. Ms. Carney and her husband filed 3 successive bankruptcies to delay the foreclosure. Ms. Carney filed an emergency motion in her bankruptcy to reimpose the automatic stay, after which Provident voluntarily agreed to postpone the sale for an additional 60 days. I submit that there was no requirement that Provident restart the foreclosure process or issue new notices in the event of subsequent events of default. I submit that she received all of the notices to which she was legally entitled. I want to address briefly.
Attorney Robinson, you heard my questions of Attorney Durkin regarding the expiration of the 5-year period after the final 35A notice.
Correct.
Do you agree that once the 5 years have expired, that Judge Wilson was obligated to engage in, I guess we can call it a balancing test to determine whether or not what followed was fundamentally unfair or not?
I don't think he needed to. I think the fact that he did it was really a belt and suspenders sort of approach. I don't think he needed to, because I think legally she received the notices to which she was entitled. I don't concede that there was a deficiency in the notices. Assuming there was a deficiency in the notices,
Assume that there was, for
Yep.
purposes of my question.
correct. And that puts you into the Schumacher analysis, Your Honor, which is correct. Whether or not any irregularity in the notice was so egregious as to render the foreclosure itself fundamentally unfair. The reason the court got to that analysis is because Chapter 35A is not a part of the statutory power of sale. That's the holding from Schumacher. As a result of that, any deficiency in that notice must be so egregious as to render the sale fundamentally unfair. Again, I think you only get to that analysis if you find that there's a deficiency in the notice itself.
Assuming we get to that analysis, under what standard do we review Judge Wilson's determination? Because it's a sort of balancing test, does he have discretion, or you tell me what is the standard of review?
I think you were spot on, Your Honor, when you were asking the question of Mr. Durden. The factual predicate for finding whether or not the sale was so fundamentally unfair really hinges on a fact-driven analysis. And Judge Wilson's 27-page opinion made lots of findings of fact. He found Ms. Carney to be incredible on a number of occasions. He found that any delay in the foreclosure was occasioned by her. He found that Provident issued no less than 8 invitations to submit applications for loan modifications. He found that
I'm sorry for interrupting, but Attorney Durden has acknowledged that they are not arguing, or he is not arguing, that the findings of fact were clearly erroneous. As I understand the appellant's argument, it's that the judge erred in his balancing. He erred in his overall determination under the totality of circumstances. So that goes back to my question, which is, assuming the findings of fact are not clearly erroneous, under what standard do we review Judge Wilson's ultimate determination?
it would be an abuse of discretion. You have to find that he was incorrect in his application of the facts as he found them to the decision that his conclusion that the foreclosure sale was not fundamentally unfair. And I don't think you can, I'm confident that you shouldn't be able to reach that result on these facts. Judge Wilson, again, as I was saying, made a number of factual findings in this case that are critical to resolution of that particular issue. Any delay was occasioned by Ms. Carney, not Provident. She received multiple invitations to avoid foreclosure. Her so-called offer to pay $50,000 conditioned upon some unspecified plan in the future to pay the rest was so vague and unsupported by proof of funds that Provident was well justified in declining that offer. Provident voluntarily postponed the sale for 60 days after she filed an emergency motion to reimpose the automatic stay. Judge Wilson found as a fact, and I think there's nothing to show that he was clearly erroneous, that Ms. Carney never asked for a payoff figure. There's no evidence in the trial record below as to how much money Ms. Carney actually had in her claimed annuity. And as I pointed out in my papers, it's a moving target. It says one thing on one page of the brief and something else somewhere else in the brief, and then she argued at trial it was something else. When you take all of those factors together, Judge Wilson was well within his discretion after he found those facts to find that these circumstances, even assuming that there was a defect in the 35A notice, even assuming that, which I point out and which I in no way concede, that these facts do not constitute anything that would render the foreclosure fundamentally unfair. This was a transparent, commercially reasonable foreclosure sale. Ms. Carney has thrown a plate of spaghetti at the wall on this case from the very beginning. And many of the arguments, by the way, were presented for the first time at trial, but each one was individually addressed and individually knocked down. The claim that there was no auctioneer on the property to continue the sale by public proclamation. Judge Wilson found that's not factually correct. He credited the auctioneer. He did not credit Ms. Carney. Ms. Carney claimed that she never received the April 3rd, 2012 letter, which advised her that if she didn't make payment within 30 days, the balance was going to be accelerated. She claims she didn't receive that. Judge Wilson discredited that testimony. Ms. Carney raised for the first time here on appeal the notion that there's somehow an arguable point or a question about whether or not she needed a new 35A notice by virtue of the fact that we don't know when the loan was accelerated. She never addressed, that was never claimed in her complaint. It was never raised in her proposed findings of fact. It was not addressed at trial. It was not, there were no questions asked of Providence witness with regard to acceleration. It was raised for the first time here on appeal. And she completely overlooks the April 3rd, 2012 letter, which Judge Wilson found that she in fact did receive, which absolutely told her that the loan was going to be accelerated. So I would suggest that to the extent that argument is being advanced in this appeal, it should be summarily discredited. The issues, and I just want to briefly touch on this while I have a little time remaining. These irregularities and failure to negotiate are complete red herrings. Judge Wilson completely properly found that these so-called irregularities were in fact entirely regular. And they were not raised, by the way, in Ms. Carney's post-trial brief. But to the extent that she's claiming, and I want to address Your Honor, Judge Hand's comment or question, to the extent that there's somehow an argument that, it's Ms. Milligan, by the way, that Ms. Milligan needed a power of attorney from her principal, there's no legal authority for that proposition. And you heard Attorney Durden essentially acknowledge as much today. That's not a part of the statutory power of sale. Ms. Carney, in fact, would have no standing even to challenge that issue. So there's nothing there. There's no argument. There's no legal principle that says that the bidding entity needs to have a power of attorney or needs to have a particular license. These arguments should be summarily dismissed. To the extent there's a challenge with respect to the failure to negotiate, there is ample federal and state authority that stands for the proposition that where there is no underlying contractual obligation making the mortgagee obligated to negotiate, the failure to negotiate does not give rise to a breach of the covenant of good faith and fair dealing. So I would, again, Your Honors, I would submit that Ms. Carney has pointed to no authority for the contention that either Ms. Milligan needed to be licensed or that she needed to have a power of attorney in order to bid at the sale. If Your Honors have any questions, I'd be happy to address them. I would like to just very briefly address the jurisdictional issue. I don't know if Your Honors had any questions about that or not. It's our position that Judge Wilson was correct in holding that the Superior Court, as a court of general jurisdiction, was fully empowered to adjudicate the rights and liabilities of the parties in this case. Because he found there was no violation with respect to the foreclosure, the jurisdiction of the land court was not implicated. We fully support that. We agree with that position. We have also raised in our papers and throughout the case arguments that the foreclosure sale was perfectly appropriate and that Ms. Carney's arguments to the contrary should be disregarded by virtue of res judicata and judicial estoppel. But I'm going to rest on my papers with respect to those arguments unless Your Honors have any questions with respect to them. And so for those reasons, Provident is asking that this judgment be affirmed in all respects.
All right, thank you very much. Any questions?
Thank you, Your Honors, thank you, Your Honors, for your time. And by the way, I thank you for granting my or accommodating my request to move this matter to the front of the line today. I appreciate that.
All right. That concludes Attorney Robinson's argument, and Attorney Spencer, when you see the time clock, you may begin.
May it please the court. Good morning, justices. I first want to address two issues that are at issue here. The first is in the verified complaint, as you can see from the record, there were no claims made against my client, which was the ultimate purchaser from the foreclosure sale. The only reason my client is involved is because he had ownership via registered land, recorded title, in which he got the foreclosure deed. Subsequent thereto, the preliminary injunction was in fact issued by a different judge than Judge Wilson in the Superior Court. When I first filed my appearance in January of 2020, shortly before trial, I made those claims at the pretrial conference with regards to jurisdiction of the Superior Court as it affects title to registered land. Again, as my brother Robinson stated, we agree that the Superior Court has general jurisdiction and heard the case, and the case was essentially lost on the facts. But nevertheless, as my client is kind of the innocent party herein, there are two issues with regards to my client. The first being that had Attorney Durden requested or required that the foreclosure be unwound, the only proper jurisdiction would have been land court. Land court has exclusive jurisdiction. Therefore, the many prayers for release in which he had, one of which is monetary damages, the other one of which is also the undoing or unwinding of the foreclosure, that could not have happened in the Superior Court. And Judge Wilson found that in his post-trial findings to my emergency motion for clarification, which was the result of Attorney Durden telling my client that he could not sell the property. Secondary to that is, given the fact that the Superior Court did not have a jurisdiction to unwind the foreclosure, we also have the issue of Mass General Laws 244, which provides a 3-year statute of limitations with regards to once an affidavit via foreclosure is recorded, the plaintiff or any party who challenges the foreclosure has 3 years in which to record a copy of the true complaint in the registered land court in this case, in which he failed, refused, or she failed, refused, or neglected to do. That expiration was 4/27/2020, and to date, there still hasn't been a recorded verification or verified copy of the complaint for which to impose that statute challenging. Therefore, the foreclosure cannot be unwound. My client had good, clear, marketable title, certificate of title in the land court, and subsequently the sale is to a third party for value, which cannot be touched. I too would like you to affirm the judgment, and I thank you for your time.
Thank you very much. Any other questions from the panel? Seeing none, we wish to thank all of you who argued today. These are high stakes and difficult cases for all parties, and we appreciate your cogent arguments. Thank you.
Your Honor.
We are live and on the record.
Thank you very much. Good morning, everyone. Welcome to the May 13th sitting of the Massachusetts Appeals Court. My name is Mary Sullivan. Your panel today will consist of me, Justice Eric Nyman, and Justice Catherine Hand. The usual rules of oral argument apply. Each side gets 15 minutes in which to argue, and there is no rebuttal. You can assume that we're familiar with your briefs and the record. We encourage you to go to the heart of your argument. And you're welcome to use all of your time, but if you don't need to, you're also welcome to rest the balance of your argument on your briefs. We hope to have no technical issues today. If we do, we will do our best to get them resolved. For those of you who may be watching this on YouTube, the screen may go temporarily dark, but we will return. And finally, if you happen to see us look away, from the center of the screen for a moment, we mean no disrespect and we are fully attentive to your arguments. It's just that our case materials are to one side of the screen or another. The case we are going to hear now is 20P0705, Bernstein versus members of the Planning Board of the Town of Wayland. Attorney Roloff, you may begin when the timer appears where the seal now is. There you go.
Thank you. May it please the court. My name is Jeffrey Roloffs, counsel for the plaintiffs' appellants, David and Kathleen Bernstein. In this appeal, the plaintiffs are asking the court to vacate the Superior Court's grant of relief to the town of Wayland from the turning restrictions required by sections 1F7 and 1G2 of the 2008 consent decree, and also from the police patrol provisions of section 1F8. which target compliance with the turn restrictions, but also speed enforcement. The Superior Court's decision guts the mitigation program that the plaintiffs bargained for in 2008, granting relief from provisions that are among the most valuable in achieving the primary objectives of the mitigation program. The decision ignores narrower remedies identified by the plaintiffs during the evidentiary hearings to Wayland's safety concerns. It fails to account for possible future increases in traffic on Gleason Lane associated with the town center project, providing for no ongoing monitoring of traffic conditions. It completely disregards Wayland's obligation under the consent judgment to defend it, to cooperate with the plaintiffs, and to act in good faith to achieve its terms and objectives. And at no time has the court or Wayland ever attempted to reconcile its many attacks on the judgment with those obligations. The decision also doesn't adhere to the applicable legal standard, and I'd like to focus on that for a few minutes. The legal standard applicable to requests for relief from judgments under Rule 60b-6 imposes a high burden on the party seeking relief, particularly, as the SJC notes in the Tibbetts case, where the judgment was entered by the consent of the parties and where the parties agreed that the judgment could not be modified without the other party's consent, a provision that we have in this consent judgment. In addition to the SJC's decisions in Tibbetts and the Owens case, which we reference in our brief, I urge the court to spend the time to review the United States Supreme Court's decision in the Rufo versus Inmates of Suffolk County Jail decision, which really established the legal standard applicable to these cases, and also the District Court of Massachusetts decisions that followed the Supreme Court's decision, because it was in those decisions that the federal court wrangled with questions of whether or not the circumstances that the sheriff was complaining about were foreseen when the judgment had been entered or were foreseeable, and also wrangled with the questions of whether or not the requested remedy was narrowly tailored so that the objectives of the underlying consent judgment could be preserved. In these cases, relief is only supposed to be granted in exceptional or extraordinary circumstances. To warrant relief, the party requesting the relief has a high burden. A burden of demonstrating, number one, that there are changed circumstances that present significant issues. So there's a significance element to it. Two, that the changes were unanticipated when the judgment was entered. Relief is not warranted if the circumstances were anticipated and considered at the time judgment was entered.
Attorney Roloffs, how specific does your client argue that the anticipated or issues need to be at the outset? In other words, if there's a general concern about safety, is the determination that there's a more specific realized concern about safety at a later time enough from the town's perspective?
I think generally it is enough. I would concede that if the impacts that were anticipated at the time of judgment were significantly less than what actually occurred, then that would be a relevant factor. And that's similar to the Rufo situation, where the district court concluded that the increase in the jail population was something that was anticipated. What wasn't anticipated was the rate of increase.
Right.
On that issue, though, in this case, looking at the evidence, and we had this discussion with the Superior Court Justice as well, the town did not present evidence on the question of what they anticipated when they entered the judgment. The plaintiffs did. And primarily through Mr. Turkington, but also through testimony of the town's traffic consultant, it's clear that the issues they're complaining about now were anticipated, particularly with respect to drivers being concerned with the convenience of it and looking to circumvent the turn restrictions. And that was a point that even Chief Irving had expressed before the Selectmen and Board of Road Commissioners agreed to the consent judgment.
What if those were issues that were anticipated, but they changed in degree over time?
I think that might be relevant, Your Honor, but the evidence in this case doesn't establish that that happened. And in fact,
as I understand, more to the point, as I understand your argument, it's that because the judge did not go back to what was known in 2008 in her analysis, by definition, her analysis must be deficient. Is that a correct statement?
yes, that is correct, Your Honor. You can't do a relative comparison of what was anticipated versus what they're seeing now if there's no evidence on what was anticipated. The only evidence on what was anticipated is what the plaintiffs offered through the evidentiary hearing.
If you are correct about that and the analysis was deficient, does that mean that this has to go back for a new hearing before the judge, even if the hearing were limited to the evidence already admitted? We're not a fact-finding court. So what would your remedy be?
Well, I actually think the remedy here is to just vacate the judgment. It was very clear. There was a lot of discussion before the Superior Court during the most recent evidentiary hearing that this was an element of the legal standard that the town had to meet, and the town opted not to present evidence on what was anticipated in 2008. So they had their opportunity to meet the onerous burden that was on them, and they failed to meet it. So I think it justifies vacating the judgment and committing the town to continuing with its obligations to implement those turn restrictions. And remember, there's ongoing monitoring here. So if there's additional evidence, I suppose, that if there are changes that they can then say were significantly different than what was anticipated, I suppose there's nothing preventing them from coming back at some future date to address those conditions. But
well, I'm sorry, go ahead.
Just one follow-up question, just to put your argument in context. In addition to the ongoing argument, monitoring and the speed bumps, what are the other mitigation measures currently in place?
So those other measures, Your Honor, would be found in two sections of the consent judgment. And I do think it's really important.
And I've looked at it, but just
Okay.
if you could just give us a quick, 1, 2, 3, just
Yeah, that's fine. So if you looked to the baseline measures that the town agreed to implement permanently, those included a 25-mile-an-hour speed limit, a truck restriction, the tier 1 speed tables, some signs for drivers approaching Gleason Lane, telling them that they can't access the town center. But one of those baseline measures was the weekend midday turn restrictions that the town.
Understood, but it's the trucks, the speed bumps, the signs, and the monitoring.
Correct. Those are still in play.
But you view the turns as central. Okay, thank you very much. Thank you, Justice Nyman.
Sure.
I do, Your Honor. And I think it's safe to say that the plaintiffs never would have resolved and agreed to dismiss their original appeal.
I think Judge Nyman had a question for you.
So
I'm sorry.
Going back to the issue of what was and was not considered in 2008, and I'm at Record Appendix Volume 8, page 275. The judge rejected your argument below and said, the question is whether the town understood and appreciated the actual impact the limited turn restrictions would have on the safety of the community when they agreed to the terms of the consent judgment. The judge then went on to make a finding that the town's witnesses credibly testified that only when the limited turn restrictions went into effect did they truly appreciate the consequences of those restrictions and their impact on safety. So this reverts to my earlier question. I framed it earlier in terms of degree, but as I understand the judge's finding, she is saying that the town did essentially make a different determination in 2015, 2016 than they had made in 2008. They couldn't appreciate the difference until they saw it go into effect, appears to be what the judge concluded. And I guess my question for you is, number one, if that is a finding of fact, how is it clearly erroneous? Well, why don't we start with that?
Yeah, it's fine, Your Honor. I mean, it's clearly erroneous because there's actually nothing in the evidence presented by the town that supports the finding.
The judge says this was, the judge then says right after, this was amply supported by the town officials' personal observations and complaints they received from others in the town while the limited term restrictions were in place. Are you saying that the judge conjured that finding, or you're so?
I mean, I think the judge truly believed that, but I don't think that there's evidence in the record that supports it. The evidence is not sufficient to support that finding. And my question is whether or not that's an understanding that she developed in, there were also arguments by counsel during the proceedings. And I don't know if she came to that conclusion possibly based on those arguments. But if you review the record, there's no evidence that the town presented related to what they anticipated or didn't. In addition to that, the evidence does show, I'm sorry, you did have a second part of your question.
You've answered my question.
Okay. I mean, the evidence also showed, Your Honor, that, even if there was some, so let's take Chief Irving, for example. He had objected to term restrictions before the town agreed to accept them as part of this mitigation program. I don't believe that he ever testified that the circumvention maneuvers of drivers was worse than what he had anticipated. Yeah, I don't think he says that anywhere. Even if they were, there's nothing that quantifies that the incremental difference. There's nothing in the record that quantifies how many maneuvers there were. There's nothing to indicate that there were ever any accidents. So there's no reasonable basis to form a conclusion that what the town is seeing now, or when the term restrictions were in place, was to some degree greater than what they anticipated back in 2008.
If I may, as a question of law, if they anticipated the problem, but they didn't, let's say, wholly anticipate it, which is what I think the judge is saying in her findings. They knew that there would be differences, but they didn't expect this. Does that satisfy the matter of degree test as you have described it in Rufo? Or is it just that they made a mistake, but they made a deal?
So
what's your position as a matter of law?
I think you need to tease her conclusion apart. So there would be a fact. So she's made a factual determination that the impacts are greater than what they expected. But then there's a legal component to the conclusion that goes to the legal standard that applies. And that's whether the difference in degree is significant enough to warrant relief. And that's where you get into a legal conclusion and a question of whether or not she abused her discretion in applying the legal standards. So I think her conclusion is a combination of a factual finding and then, a legal, applying that fact to the legal standard that applies here.
Could I ask a slightly different question? What's your position about the effect of your client's failure to appeal the restriction at the highest tier on your argument now?
I don't think there's any effect in that because, as we explained in our brief, the Section 1G4 measures had little value to the purposes of the judgment. My client agreed to let go of that mitigation measure because it wasn't important. My client appealed in a timely fashion right after the court revised its ruling to extend it beyond Section IG4 to the Section IF7, IG, IF8, and IG2 measures. Those are the issues that were presented to this court back in 2017 and 2018, and which led the court to remand the matter back to the Superior Court.
All right. Does the panel have any further questions? Thank you for your argument, Attorney Quizzle. When the timer appears, you may begin.
Good morning, Your Honors. May it please the court, Amy Questle for the town of Wayland, Town Council for Wayland. In this instance, the judge did not abuse her discretion at all. She has the ability, she has the discretion to allow relief from a consent judgment when there are exceptional circumstances. And in this case, there were. Probably the most exceptional circumstances, which is public safety. So we had the police chief, we had the fire chief, we had the traffic expert, all had serious concerns regarding the public safety with the limited turn restrictions. With regard to Justice Hand's last question, I don't necessarily agree because the appeal, the March 27th order under IG4, which were the permanent turn restrictions, were we sought relief for the 24-hour turn restrictions. So underneath the 24-hour turn restrictions, we have the limited turn restrictions, which are less in time, in duration. So I do think that there is a fatal flaw that was not appealed, but again, only discussing the limited turn restrictions. The public safety concerns were with regard to response times, emergency response times, confusion and distracted driving, which is, I don't know if that was such a big thing in 2008 as it is now with, texting and driving and things like that, but that was a serious concern of the police chief, that if we have these signs that say no turn from 11 to 6, are people, oh, what time is it? Is it 10:58? Can I make the turn? Can I not make the turn? People are, they're pausing when they shouldn't be, when they should be going, things like that.
Attorney Questle, sorry to interrupt you, but where is there support in the record for the judge's conclusion that the town's witnesses credibly testified that only when the limited turn restrictions went into effect did they truly appreciate the consequences of those restrictions and their impact on safety? Specifically, where, can you give me record sites, or can you point to a particular witness's testimony or particular evidence in the record that supports that proposition?
Sure. Police Chief Irving, in both the 2016 hearing and the 2019 hearing, has specifically stated that complaints of residents, complaints of police officers having to pull over people because they made this turn, Chief Irving witnessed illegal maneuvering where cars would follow the directions of the sign. They would take the permitted turn and then turn around, do a U-turn or pull into somebody's driveway. That's all in the record. None of that was necessarily anticipated. The complaints, particularly the complaints from the residents of Gleason Lane that do not want these turn restrictions.
Did he testify that those were things? Did he say that? Did he testify
Yes.
these things we didn't know in 2008?
No, he did not testify that he did not specifically not know that in 2008. He testified that he had concerns in 2008 over these turn restrictions. I actually think that the Rufo case supports our position that yes, there were, and this was what the judge was focusing on, was yes, there were safety concerns, I'm sure, in 2008. However, they were not fully materialized, and that the degree of them was not anticipated until they actually went into place. And then it became, this is a safety issue. Now, the other thing that I
think Attorney Roloffs would say there was no testimony to that effect. So we have to be able to draw an inference that was something that changed in degree over time.
Well, there is testimony that Chief Irving had concerns of the limited turn restrictions in 2008. And then there is testimony from Chief Irving as to the degree of his concerns once these things went into effect.
Does that help you or hurt you? If he knew about it in 2008 and he anticipated this problem in 08, but they nonetheless made the deal. I mean, that's, I think, essentially the question of law that we have to answer. It may be a mixed question of law or fact. Colloquially put, did things get a lot worse, or is the town welching on a deal? I think, that's the issue.
Correct.
So it would be helpful for us to know what evidence you rely on in the record to show that, no, this was materially much worse than we ever anticipated in 2008.
So again, we have the police chief's testimony, which is in the record, which I think that again, the Rufo case actually helps our position, because it's the degree of this public safety concern that came to light once these limited turn restrictions became in effect. And that is why the town, oh, I'm sorry.
No, I didn't mean to interrupt you. Go ahead.
I was just going to say, that is why the town, once these did go into effect, that's why the town sought temporary relief, to try and figure out how to continue to address the concerns of the plaintiff, but also the public safety issue. And if you wanted to, I did have another point, but
Go ahead.
So I did just want to clear up one thing that Justice Sullivan, you asked about the measures that are currently in place. One of the measures that was not, I didn't hear, were speed humps. There's 9 speed humps on Gleason Lane.
They were mentioned.
Oh, I'm sorry. Okay. Sorry.
So Attorney Quezzel, with respect to the evidence of the material change, what about Chief Irving's testimony, other than the fact that there were observed instances of people turning around in either the country club parking lot or driveways, that made a material change, other than a repetition of the same concerns from 2008 about the possibility, maybe a more detailed description, but a description of certain potential risks? What material change do we see in the record? What evidence of that?
The fact that I think that the other thing that the other issue was that with the limited turn restrictions, one of the issues that came to light was the response time for the fire department when the limited turn restrictions were in place. They realized that was very confusing for first responders to have to know when they had to go around, which I think was there was testimony that added minutes to, but depending on where the emergency was on Gleason Lane, it could add minutes. So again, we're at this confusion where they jump in their fire truck. Are they supposed to know if it's 10:55? Can they make it, or do they have to go around? It's not conducive to first responders to getting there as fast as they can. That was definitely discussed at length in the 2019 evidentiary hearings. And so, if I may, I would say that again, this court, as Justice Sullivan correctly put, is not a fact-finding tribunal. These issues were well thought out and discussed and presented in I think it was 4 days total. So we had 2016, we had evidentiary hearings. And then in 2019, we had maybe it was only 3 days of evidentiary hearings whereby witnesses were presented. This was not, this wasn't, in Tibbetts where there was an ex parte change of the consent, the consent decree. This was most definitely, the evidentiary hearings took place, evidence was presented, and this is what the judge found. These were the facts that she found. She did not abuse her discretion in any way. There is no error of law here. And I would ask that this court affirm the Superior Court's March 2020 memorandum of decision and order, because it was properly decided. It was well thought out. And that's all I have.
All right, thank you. Any further questions from the panel? All right, thank you both for your arguments.
Thank you.
Thank
Have
you.
a good day.
You too.
Thank you. Bye, Jeff.
Right.
We are live and on the record.
Good morning, everyone. Welcome to the May 13th session of the Massachusetts Appeals Court. My name is Mary Sullivan. Your panel today will consist of me, Justice Eric Nyman, and Justice Catherine Hand. The usual rules of oral argument are going to apply in this virtual sitting. Each side will have 15 minutes. There is no rebuttal. You can assume a familiarity with your briefs in the record, and we encourage you to get to the heart of your argument. And you're welcome to use your full time, but you are not required to do so. For those of you who may be watching on YouTube, we hope that we will have no technical difficulties. If we do, your screen may go dark for a period of time while we fix them. And if that happens, we will be back. And finally, if you happen to see any of us look away from the screen momentarily, we mean no disrespect, and we are fully attentive to your arguments. It's just sometimes necessary to look to one side or another in order to review our case materials, briefs, transcripts, and the like. So our next case is 20P1211, Benedetto versus Benedetto. And Attorney Sweet, you may begin.
Thank you, Your Honor.
And, oh, excuse me, I would remind you that the case is partially impounded.
So the main basis for my client's appeal, Your Honor, is the fact that the order by the trial court for my client to file joint income tax returns for 2017 and 2018 with his former spouse violates our supremacy clause. So our supremacy clause says the federal law is the supreme law of the land. And of course, our federal law allows a couple to decide whether to file joint tax returns or whether to elect to file individually. And this trial court order eliminated my client's ability to make that choice. And in this particular case, it's so significant, of course, because my client during those tax years in question was paying alimony at the rate of 35% of the differences in the parties' incomes while the divorce was pending. So in effect, by removing my client's ability to do that, he is going to now be sharing in his former spouse's tax liability on those alimony payments that he made to her. And this order, of course—
I'm going to interrupt you right there.
Sure.
I'm going to ask you to slow down a little bit too.
Oh, sure.
So that we can fully understand you. There's a preliminary issue here, and that is whether or not this issue is properly preserved for appeal. As I understand your argument, you say two things in response to that. One is essentially, we couldn't have known about this until the judge issued the judgment and her rationale. And two is it's an issue of first impression. So that begs this question, which is, first of all, why didn't you file something before the trial judge? A motion for clarification, a motion for reconsideration, a Rule 60B motion for new, because our court is not as well equipped as the trial court to deal with an issue that has a lot of, say, a detailed factual predicate. So why don't you start with that question?
Sure. I recognize that that could have been a potential post-trial pleadings where, when I reviewed the issue, found no precedent, no case law on this issue, I thought it was sort of the better course of action to file the appeal in order to get direction on how this could be viewed. And I will say that in 25 years of practice, I've been told repeatedly by trial court judges at lobby conferences, at pretrial conferences, at even MCLE seminars, I was told that this is impermissible. We cannot order you as trial judges to compel parties to file joint tax returns. However, of course, we can make orders which take into account the consequences of a party's refusal to file a joint tax return. So for
Well,
those reasons,
If I could, though, the wife indicated a willingness to do so. And please tell me if I've missed something, but I didn't see anything in the proposed judgment from the husband, or any argument in the transcripts, or any response to the proposed findings that said, but I don't agree.
correct, for the very reasons that we believe that the trial court, such an order was impermissible under the supremacy clause. It all sort of revolves
Well,
back
it's
to that.
not impermissible if the parties agree to it, and the wife said, I'll agree to it.
With respect, my client disagreed because he had a very significant alimony order for the majority of those 2 years.
And I
And-
appreciate your position. I'm just trying to make sure that my impression is correct, which is that his disagreement was not stated to the trial judge.
That is correct. And if my recollection is correct, I mean, it was never specifically discussed whether or not they should file jointly or otherwise. Again,
That special appendix, I'm sorry for interrupting, but it's special appendix or supplemental appendix, page 19. This is in your client's proposed findings of fact and rationale. At paragraph 47, it says, quote, 2017 and 2018, the parties have not filed their 27 or 2018 joint tax returns, end quote.
I didn't mean to indicate that that fact was not in evidence. That clearly was a fact. I'm talking more about the tax implications and whether or not the parties had agreed or disagreed to file jointly. It was actually part of our stipulation of uncontested facts that did in fact exist. But what was not developed on the record was whether or not, what would those tax implications be? What was in the record, of course, is the temporary order from February 28th, 2017, which clearly said my client was ordered to pay alimony at the rate of 35% of the differences in your income. And that order was entered prior to the Tax Cuts and Jobs Act, which didn't take effect until January 1st, 2019. And this enabled my client under federal law to deduct his alimony payments to his former spouse, which was he anticipated that he would be able to do. And since the continuing alimony order was entered prior to the effective date of that act, he has in fact continued to deduct his alimony paid to his former spouse. And it certainly was anticipated that that would continue. And conversely, there's also nothing in the record that contained any indication that that would not be the case. In other words, the deductibility of his alimony tax payments would continue because the amount was modified, but the existence of the alimony order predated the Tax Cuts and Jobs Act. So again, it really does resolve back to the fact that we thought it was my client's right under the federal law to be able to file individually and get the benefit of the tax deductions. And each year he paid in excess of $50,000 of alimony to his former spouse.
So how do you get around the Fector case, which says in relevant part, a judge is not bound to grapple with the tax issues where the parties do not request the judge to consider a particular tax consequence and do not introduce evidence on the issue?
Again, I think it goes back to the fact that the order wasn't created. There was no development of the record on either side with respect to that. And so I think this is very analogous to the Smith case that I quoted in my brief, which talks about a very similar issue when it had to deal with the sex offender registry, where there was very new regulations and the objection to the registration was raised on the first time as appeal. And the court there said, we're going to listen to this because it's an issue of de novo. And we think it's important to set a precedent and to address this. And very similar in the case at bar, there is no precedent that I was able to find, and I don't believe my brother counsel found it as well, as it wasn't cited in his brief, as to what are the parameters in terms of a trial court's ability to order divorcing spouses to file a joint tax return. From here, Your Honor, I have relied on the Huntley case. I'd like to direct our attention to that because I do think that it is helpful and persuasive. Of course, that was a bankruptcy case. I do recognize that. But why it's so important and relevant is the SJC was tasked with deciding how do we view ownership interest in a tax refund from what was an intact couple in the viewpoint of a bankruptcy court proceeding. And why I think it's so important is in coming to the conclusion that the SJC should follow the separate filings rule in determining how to deal with this issue. They looked at the legislative intent behind the statute, which talked about, there was a legislative intent that joint refunds should be divided according to the spouse's contributions. Very similar to what the probate and family court does in determining the allocation of assets and liabilities between divorcing spouses. They're going to look at what was the contributions, which talks about what each party contributed to the tax withholdings, what did each party do to create the existence of either the tax refund or the tax liability, as the case may be. So I think that the SJC's interpretation of this viewpoint of how to handle a tax refund is analogous to the case at bar. And by the trial judge stating that it would be split 50-50 without really doing an assessment of how we view that under the separate filings rules, it contradicted how we should look at this particular issue.
Was that issue in Hunley raised before that trial judge?
I couldn't answer that question. I'm not sure at what point that particular issue came into the proceeding procedurally. I don't think I can answer that from the appellate argument. It certainly was, raised in the context of the argument about how to view the ownership interest in that property. And of course, they did that by looking at two things. Not only what would the hypothetical tax consequences be if this married couple filed separately, but the second piece, which is so important again, which was, well, what was the contribution of each party to the existence of that tax refund, which is so relevant to our argument here. My client not only paid income tax on his earnings, or will pay income tax in the 2017 and 2018 timeframe, but if forced to file jointly, he's also going to pay the wife's share of the tax liability equally, which is not consistent with the separate filings rule. The other point, which I'd like to shift to, Your Honor, which is the third point of my brief, is that the net effect of the trial court's ruling was that, in essence, my client is actually paying out of pocket more than 35% of the differences in their income if he is ordered to file a joint tax return and share in the tax liability for these tax payments that he made. Our alimony statute states that this is a presumptive cap, the 35%, and it shouldn't be deviated from unless there's reasons to warrant a deviation. Now, in our underlying findings, there was no rationale or addressing any of these types of issues that the net effect of the joint tax filings was actually going to increase my client's out-of-pocket payment as a result of these alimony payments. And I think to do that, again, violates the intentions behind our alimony statute, which does put a presumptive cap. And we know from Judge
Was there evidence, again, I apologize for interrupting, was there evidence before the trial judge as to what these tax consequences would be?
There wasn't. There clearly wasn't raised by either side on the trial below. Again, I think it goes back to the fact that there was, for one, I did not think it was permissible, and that's based upon 25 years of practicing in this Commonwealth. I just didn't think it was permissible. So the record was not developed, to be very clear. And I think that we need direction on how to look at that. And I'm suggesting that the bright line rule should be that moving forward, the court should not be able to order divorcing couples to file a tax refund. And that's not to say that the probate and family court doesn't have the discretion to take into account the implications of that order. And in fact, in practice, that's what they've been doing. That's at least my experience. They have been looking at what are the implications if I order you to file jointly or versus not. But there's still this bright line rule, or I submit that there should be one, that indicates you can't compel a married couple to file jointly. The other issue that's tied into that is, these aren't our facts here, but what if someone's self-employed? What if there's a question about the reliability of that information being reported by that former or soon to be former spouse? I think it raises a whole host of issues if that was to be the ruling. In our particular case here, of course, my client is a W-2 wage earner, so the wages were clear. But I do think that as a bright line rule going forward, that there shouldn't be an ability of the trial court to order the joint filing, because it does strip my client of the ability to exercise his right under federal law to make that choice about whether he files jointly or whether he files separately, especially where the alimony order that was entered was at the maximum level of the alimony statute. And unless the panel has any additional questions for me, that would conclude my argument.
Panel? Thank you very much.
Thank you.
All right. Attorney Derland.
Sandy Derland, Schmidt and Federico in Boston. Good morning, justices and counsel. Unless the panel has questions, I'll also jump into my response. And that is, I think there's a disconnect between, or there's a disconnect in the husband's argument, and it's a disconnect between the record and his argument. And that's true regardless of whether this is a case of first impression, whether it's a violation of the Alimony Reform Act, whether it's a violation of a federal statute, or whether it's a challenge to the constitutionality of an order. All require the record to reflect that, a development in the record. Husband's brief criticizes the judge for the lack of a tax analysis, and counsel has done today, and the brief also criticizes her for the effective result of the order given the percentage of alimony which was ordered. And in other words, the effective tax rate that might apply in those 2 years as a result of this order. But again, the record is entirely silent on that issue. And, case law, some of which counsel cited, on the consideration and propriety of considering tax consequences in a divorce, whether it's the Fector case, whether it's the Rice case, and whether it's a case I'm about to touch on, and that is LJS versus JES, all speak to the record and the need to develop a record. It wasn't done here, and he's waived the argument in this court as a consequence. Counsel said that there's no case law that touches on this issue, and it gets to something that Justice Nyman raised, and that is, was there any effort made to remedy the judgment once it was issued? That is precisely what occurred in the LJS JES case. That was a post-judgment motion to amend, where, and that was a case I was involved with, where the husband felt the trial court erred in applying various tax laws to an alimony obligation and a child support obligation, and brought a motion to amend with citations to appropriate tax statutes and with appropriate analysis. That is how this issue is remedied. It's somewhat risky to approach this matter in the way counsel has because of the record being devoid of the issue. And that is why I think the issue rises and falls on that. And the lack of argument and the lack of a developed record really, I think, is an open shut on this issue. Now, that said,
how could counsel have approached this differently at trial? How could the issue of tax consequences have been raised?
It's very common for the issue to be addressed either through bringing in an accountant to do an analysis on the effective rate of support alimony that will result as a consequence of an order issued by the court based on effective tax rates, differing tax rates. The husband and wife clearly have a differing tax rate on a single return in this case, given the significant delta between their incomes. That's right. How that's appropriately addressed.
But let's put it in the context of a case like this, where there are stipulations and clearly the parties are trying to keep the costs down. They're trying to avoid having a 6-week trial or a 6-month trial for that matter, and instead narrow the playing field, limit the disputes. And that it seems that wasn't anticipated to be a live dispute between the parties. And the first that the inkling that the husband had at all that this could be an issue, at least according to their representation, was not until the judgment came down.
Well, I can respond on two different levels there. The temporary order in this case, which was issued, did not address the deductibility and includability of the payment. It was issued, as counsel pointed out, before the Tax Cut and Jobs Act. There certainly could be an inference, and it's a reasonable inference, that given the percentage that Judge Conley, as the temporary orders judge, issued in this case, that it would be considered deductible, but it was not stated as such. And the code is clear that the code was clear that an alimony order has to be linked to death, and remarriage of the parties in order to make it deductible under Section 71 and Section 215 under the tax code. The Tax Cut and Jobs Act sort of has clarified that somewhat with the inference that all deductibility occurs upon an alimony payment. But nevertheless, that issue was ripe when the parties went to trial, and the husband could have addressed it. Justice Naiman, you raised the issue. You said it wasn't addressed in his proposals. It wasn't addressed in the stipulation. The issue was wide open. The only party to address it was my client in her proposal. So that was the only thing brought to the judge's attention. And in response to that, I think she acted appropriately. But the second thing is, again, I'll go back to the LJS-JES case. In that case, the tax consequences brought to the trial judge's attention, not with an accountant's testimony, but through verified post-judgment motions. So it could have been done very easily and very cost effectively by the husband had he had that concern, which he should have once the judgment entered. Now, if I may, on the issue of the supremacy clause, and this being a question of first impression, I don't think there is a violation of the supremacy clause. I don't think there is a case in Massachusetts that I'm aware of that says, on a black and white basis, a husband and a wife cannot be compelled, to file a joint return. But I think the Fector case and the cases which, follow it, the progeny, do give the trial court broad discretion on this issue. And I don't think there's a conflict between state and federal law, because generally in domestic relations cases, courts issue orders all the time that impinge on a party's statutory rights. And this was addressed, and this is not briefed, to be sure, but this is addressed in passing in a case that this court entered about 2 years ago, the Stacy case at 97-160. In that case, there was discussion how the laws or the subject of a domestic relation matter is a matter for state, not federal law. And a state law won't be overridden by federal law unless there's a harm to substantial federal interests. And as I said, states routinely impinge upon federal statutes and rights in domestic relations matters. And in the context of a tax return, the judge, I suggest, has the broad discretion to allocate responsibilities, if necessary, through a joint filing. And counsel has acknowledged the speculative aspect and speculative nature of the harm. And that speaks to the need to develop the record. So now my argument is somewhat circular. It all comes back to the record. And in here, the judge, she made an equitable decision, as all judges do in a divorce. She divided the assets equally. She divided the liabilities equitably, not equally. And she found that after they were responsible for their own personal liabilities, they would file the joint return. And that's a reasonable exercise of discretion under this record. I think the judge there could have taken judicial notice under the Williams and Massa case. I think the judge can take judicial notice of the benefit of a joint return insofar as the tax rates are concerned. I mean, it's generally, I think it's generally true that that's the lowest effective tax rate under the tax code, the federal tax code. I don't know that she did or she didn't do that, but I think the order of a joint return is, I think, a reasonable exercise of discretion, again, on this record. And as has been pointed out, my client suggested a joint return. And she suggested that the parties share refunds and responsibility on a pro rata basis. The judge ordered shared responsibility. So to the extent that there are taxes due on those returns, under that judgment, my client will actually share in a greater measure than she proposed. So in that respect, the judge also tried to forge a more equitable resolution, again, in the face of the husband not bothering to address the issue at all. And finally, at least insofar as my time is concerned, the Hunley and Marsh case. In response to a question, Justice Nyman, I do not believe, I think it was Justice Nyman, I apologize if I'm wrong. I do not believe that was brought to the judge's attention below. I point that out in my blue brief. And in that case, the so-called separate filings rule that the SJC imposed does speak to established property concepts, not those concepts which are used under Section 34. There, the SJC said, you know, when you're deciding whether a refund is part of the bankruptcy estate, you know, no other circumstance, the bankruptcy estate, it's a very narrow question. And they talked about the need to determine, and I think the decision even says, you know, this decision will require a lot of work because it requires that each party's contribution to the tax payment and withholdings be determined even in that circumstance. Again, that wasn't done below here. And I don't think that the Hunley case can be so broadly applied to a divorce, the so-called bright line that counsel mentioned, because it really would impinge on the trial court's ability to equitably allocate the liability. And, you know, if you're going to require parties to not file a joint return unless they agree, then the judge is hamstrung to some degree, and is hamstrung here because we don't know what the effect of that will be. The record would have to be developed. The withholdings and contributions to the taxes in 2017 and 2018 would have to be developed for the judge to be able to then make a determination either way as to what the appropriate filing status should be. And so I don't see this as a blanket application of a case, you know, which was only responding to a bankruptcy question certified by the First Circuit. And absent questions, I will rely on my submission.
All right, any further questions from the panel?
No, briefs were very helpful. Thank you both.
Thank you both.
Thank you.
That will conclude this argument, and the panel will be taking, so that is fine as well. We hope that there will be no technical issues today. For those of you who are watching on YouTube, if we do have an interruption, you may see that your screen goes dark. Rest assured that we will return. And if for any reason you see any of us turn to one side or another during oral argument, we do give our full attention to the litigants. You do have our full attention. It's simply that we may need to look over in order to see your brief or an appendix or a portion of a transcript to which we may be referring. And with that, we'll call the next case, which is 20P0168, Miriam Sayegh versus Stanley Helinski. Attorney Helinski, you may begin as soon as you see the timer.
Good morning, Your Honors. May it please the court and counsel. My name is Stanley Helinski. I'm appearing pro se. I clearly have issues with the default judgments that entered. I don't feel as though I was heard. I believe that I don't feel as though the circumstances that happened in 2018 were heard by the court. All that said, from a practical and legal standpoint, I fast forward to the assessment of damages hearing that took place. My argument here and there If you look at 66 of the appendix, there's a memorandum that was filed and an argument that was raised that in order for the court to determine damages at that hearing, the court needed to, consistent with productora, assess the causal connection between the admitted facts and the damages that were alleged. So, as I argued there, the case arose from my representation of the plaintiff in this case, in a medical malpractice case. According to her complaint, she discharged me, and in about a year, she represented herself pro se, and in about a year, the court dismissed the case that I represented her in, for failure to respond to repeated requests for discovery, ironically. As I had said many times during the course of these proceedings, that I was admittedly in and out of, based on whatever circumstances I was involved with. I continued to push my position that there was no causal connection. I brought a 12B6 motion. Even when we got to the assessment of damages hearing, again, I submitted to the court that the court needs to independently look at the causal connection between the admitted allegations and the damages.
Attorney Helinski.
Mm-hmm.
So there was an assessment of damages hearing. Did you order the transcript of that hearing for our review on appeal?
I did not, Your Honor.
Okay. It makes it somewhat difficult to review that issue without the benefit of seeing precisely what was put before the judge and what information and evidence and representations were placed before the judge. So can you help us with that, please?
Yeah, I'm sorry, Your Honor. It was one of those things that I did think about. It consisted of only the plaintiff getting on the stand and putting forward all her medical records that I'd stipulated to, and her saying how it affected her. That was the sum and substance of it.
How do we know that without reviewing the transcripts themselves? Where in the record do we find that that's what was presented, and where in the record the substance of it?
You can find it in the judge's, in the court's ultimate findings, as the court adopted and awarded damages. I just didn't see it germane to. I didn't see it germane to my issue. In other words, I don't disagree that those are her damages. It's what I said during the assessment hearing. It's what I say now. I don't dispute that she has those damages. I have an issue with, I was not allowed an opportunity to argue that those damages are not connected to the factual assertions and ultimately the facts by virtue of the default.
How do we know that you weren't provided that opportunity? While no one here has any reason to doubt you.
Yeah.
But we need something in the record, that evidence that backs up that proposition.
My belief was that the memorandum would provide sufficient evidence that I don't think there is anything on the record. It was my position that I put forward in the memorandum that the court really needs to consider the causal connection. Even if there was a 12B6 motion that had been denied, that's not enough. And I cited case law in that memorandum. And then the ultimate, I figured that between the two, the memorandum and the judge's ultimate findings, which were lengthy, that there would be no dispute. And I don't think there is a dispute. I don't think the plaintiff would dispute that either. So I apologize if that's something that you would want to have seen, but I did make a decision that it was all stipulated damages without any argument whatsoever regarding the connection between what I would be admitted to having done given the default and the damages that she was claiming. So that,
Counsel, as I understand it, you're not challenging the amount of the damages, you're challenging causation. Is that correct?
right, Your Honor, and that's why I didn't see it fit to order the transcripts. You know, I didn't want to delay either. I didn't want to delay it, and I know that if I just go forward without transcripts.
So the rule with respect to a default, when a default has been entered under 55A, and we move on to an assessment of damages hearing where damages are not automatically or readily quantifiable, is that the well-pleaded allegations of the complaint are taken as true. We don't, nor does the motion judge go behind them. And the complaint, as I look at it, which begins on Record Appendix 10, alleges a claim of legal malpractice, that that discovery requests were not responded to, that no steps were taken to obtain an expert report, that upon discharge there was a refusal to turn over the file. You may wish to dispute those, but as I understand the legal standard on a default, the issue of causation has closed as a matter of liability. Is that understanding incorrect? And if so, what case can you point to tell me that the issue of causation can be relitigated at the assessment of damages hearing?
Well, I appreciate that, Your Honor, and I respectfully do disagree with that, and that was the purpose of the memorandum of understanding. I mean, I'm sorry, the memorandum regarding the assessment of damages hearing that you see at 66 of the appendix.
Yes, I know you wanted to dispute that. I'm asking you to tell me what is your legal basis for asserting a right to dispute it.
So that would be productora, because you know, and as I've also briefed, the allegations that are accepted as true are only those factual allegations. They're not conclusory allegations. So any allegations that say you were wrong, that's a conclusory allegation that's not in the consideration of you know, whatever the assessment is. Putting all those aside, all of the conclusory allegations, the defendant committed legal malpractice, and just looking at the factual allegations that are taken as true as a product of the default, productora, Jones. That's why I was putting to the memorandum as well. I did raise these issues. Productora, taken together with Jones, there is not a lot of case law on this issue, but I did dig very deeply into it. There's a difference between the federal and the state. The Jones case that's cited does discuss this. There's not a lot of discussion about it because I think this is kind of an unusual situation. I don't think the situation where you have a defaulting defendant that actually is showing up. It's usually much more cleaner than that. So looking at those two cases, yes, I do make an argument there that I think is the correct one, that the court, even though damages are disputed. I mean, I shouldn't say damages are undisputed. Damages are disputed. I don't dispute that those are the damages that she claims. In other words, I don't dispute that she didn't go to a doctor at a certain time or that she has pain. I do dispute that those are damages related to this case. I 100% dispute those in every cent of them, because of the causality issue. And then, of course, I have to mention that there was a Rule 11 motion, even though these were accepted as true. There was a Rule 11 motion that I brought before the default entered that really undercut a lot of these allegations. I've never brought a Rule 11 motion ever in my life, but because I had the benefit of all these communications, I felt as though the allegations in the complaint were materially false, and that counsel should have known about them and that the plaintiff should have known about them.
Once a default enters, or for that matter, a default judgment enters.
Sure.
Are you entitled to raise your Rule 11 and or Rule 12 motions on appeal?
It was filed before the default entered.
I understand, but
Right.
once a default enters and once a default judgment enters,
I think it wipes out all of the, with the exception of, I may be wrong, but with the exception of pending motions that were not heard by the court ever.
so you would agree that your Rule 11 and your Rule 12 motions were, to use your words, wiped out by the entry of the default?
I don't think I do agree with that. I don't agree. I don't agree with that. I don't think.
Excuse me, I thought that's what you just said.
No. I'm sorry. I think that if a default enters, I may be wrong about this. My understanding is when a default enters, the ability to appeal certain issues, to raise certain issues on appeal are not forestalled. If there
Do you
was
have any
error,
authority for that?
I don't. I didn't consider that to be an issue. But again, I go back to the issue that I don't believe it was right for default to enter to begin with, for the reasons I mentioned in my brief, and I'm happy to talk about those as well. I don't feel as though I was heard through that whole year that this was going on. And as an officer of the court who's been in trial courts for 20 years, I've extended that so many times, those courtesies, that all culminated into my 73-year-old mother dying, and the turmoil that followed, and a young daughter that I had to deal with as well through that. And that was just the end of the year. And if you look at all of the default judgments, I don't feel like they were, it's not that I don't see anywhere that any of that was credited, that anything was given to me for all of these circumstances that have happened through the year. And I know it's me.
Well, does the record suggests that after 2018, when you had this confluence of issues, that judges did give you additional time to file certain responses and to respond to the various issues and pleadings. And it was in 2019 that the judge made these determinations, well after the issues in 2018 that you raised below and in your brief.
So, Your Honor, my mother passed in the end of November of 2018. I was supposed, what led to this, I had done what had been asked of me before my mother passed, which I think was November 8th. The court said, I'll remove the default. Here's what you need to do. I did most of them, but then I didn't show up for I had an issue that I didn't show up for a deposition. I lost my wallet and I decided I wasn't going to drive. I asked this counsel, if we could put it off for whatever amount of time until I can drive. He said, no, I'm moving for a default. That was what led to this default judgment, precisely what led to it. So it was really only a month, but you don't see the order. She didn't act on it until April.
Well, there was also the failure to pay the monetary sanctions,
That's
which you were
true. That
given
is
90
true.
days to pay.
Yes, that is true as well. I just couldn't. I wasn't working for a long time during that period. All of this happening in 2018 didn't just put stress on me. It put financial stress on me because I couldn't work. And then I was in the hospital with my mother for literally 2 months by her side every single day until she passed. That was from September, October, every single day. I was right by her side until she passed.
All right. Well,
So,
it appears that your time has expired.
okay. I do appreciate it, Your Honors.
Does the panel have any further questions? Right. Thank you.
Thank you.
Attorney Creamer.
Yes, good morning, Your Honors. Enough is enough is sort of my reaction to all of this. Mr. Holinsky was defaulted and a judgment entered against him because from the time the action was filed against him in December 2017, he repeatedly refused to comply with court orders repeatedly. Refused to comply with court orders, he refused to comply with court rules. You know, he was ordered in June of 2018 to file an answer. He didn't do it. He was sent a notice of default in July of 2018. Didn't respond to it. The case was on for a damages hearing in September of 2018. He didn't show up. He makes an ex parte call to the court the morning of the hearing after my client, who, by the way, it's been more than a decade since she suffered the injuries that's been plaguing her all this time. I mean, this is a woman whose legs shattered, has been dealing with daily pain for over a decade, and has never been able to receive compensation because of all the things Mr. Holinsky did. But she had come to the day before the hearing that he just decided not to show up for. She came to my office from out of state at her own expense in great pain, to prepare for a hearing. We appeared on the day, and the court granted Mr. Holinsky a courtesy. Didn't have the damages hearing in September 2018 that's scheduled. You know, even though my client had done all the things that she was supposed to do, and gave him an opportunity to file a motion to vacate the default. Set a deadline for him to file a motion. He didn't do it. The court held a hearing November of 2018 where the court specifically found two things. One, that he was unpersuaded by anything Mr. Holinsky was saying about why he didn't show up for the hearing in September. And two, that even though the court was going to grant him another courtesy and vacate the default, that Mr. Holinsky should not take that as acknowledgement or condoning the word, I think the words the judge used, with a cavalier manner in which Mr. Holinsky was treating the case. The judge is very clear in November 2018. You have to comply with these discovery obligations that I'm saying down and these deadlines. You have to pay the sanctions that are being awarded against you. Mr. Holinsky asked for 90 days. The court again granted him a courtesy and said, okay, it's more than what I typically grant, but I'll give you 90 days. And Mr. Holinsky did none of it. Didn't show for his deposition, didn't pay the sanctions. He had a court order to pay sanctions and he just refused to do it, ignored it. You know, several days after the deadline passed, he filed an application with the Supreme Judicial Court to seek to strike it. It was denied. He didn't file, he didn't pay the sanctions after that. He was defaulted in March of 2019 because of all of this, because of all these issues, and was in the order of the default was told he needed to appear and show cause why a complaint for contempt shouldn't be held against him. And he still didn't pay the sanctions.
We understand. I'm sorry, Attorney Kim. We know the facts of the case, so we don't need to go through them all again.
Fair enough, Your Honor.
Let me ask you this question. Attorney Holinsky offered during his argument, I think, that he was not given the opportunity to argue causation at the damages assessment hearing. Is there anything in the record that supports that proposition? And to your recollection, was that argued at the assessment hearing?
I don't think there's anything on the record that he's provided that supports what he's saying. He made that argument to the judge, but I don't know that he chose not to file, to obtain a transcript of the hearing. So it's not before this court. It was his obligation to obtain a trial transcript. He chose not to. I know part of I've filed a number of motions in this appeal because his sort of dilatory behavior continued even throughout this appeal. And
let me ask you, what do you think the scope is of a defaulting defendant's right to challenge the issue of causation at an assessment of damages hearing? Is the defendant confined to the well-pleaded allegations of the complaint, or is there some latitude for exploring what the causally related damages are?
No, he's confined to the pleading, what's pled in the complaint. The cases that he talks about are not cases that go to the issue that he wants them to address. Those are cases that talk about the fact that when the court awards damages, there has to be a factual basis for the damage award that the court chooses. The court just can't pick a number out of the air. The court has to have some factual basis to support the amount of damages that are being assessed. Those cases do not in any way suggest that the court has to make some finding of causation, because as Your Honor pointed out, once he is defaulted, he is confined to the well-pleaded facts of the complaint.
So it's the well-pleaded facts, and it seems to me that the key paragraph of the complaint is paragraph 51, which says plaintiff's underlying action for medical malpractice damages was dismissed with prejudice as a direct proximate result of Helinski's negligence, thus forever depriving her of the opportunity to receive just compensation. Is that a statement of fact, or is that a conclusion? Is that the type of conclusory allegation to which we don't defer?
Well, I
Or
think
a mix.
I would say, Your Honor, there's more in the complaint that sets out the factual basis that shows the causal connection between the bad result that she received in her case and what Mr. Helinski did. I believe it's more than what's said in just that paragraph.
Oh, I agree that, I mean, you do have 47 paragraphs of fact here. But I was looking for the words cause or proximate cause, and that appeared to be the paragraph
Right.
that contained it.
Yes. Well, I would argue, Honor, that, the complaint sets out all of the facts that support the assertion of proximate cause. Yeah. The court, the Superior Court reviewed this under the 12B6 standard.
Well, we don't do it under the 12B6 standard, though, once we're at a default an assessment of damages hearing. I suppose they're very similar, but
correct. I mean, there are, and I can list them out if the court would like, but there are numerous facts laid out in the complaint that show exactly, the malpractice committed by Attorney Helinski and how that resulted in her and in Ms. Sayag, losing her ability to prosecute her case. Yeah.
Well, you allege that as a result of his acts, the case was dismissed.
Correct.
I think that's your point.
Correct. And that's factually what happened. I have much more to say about, Mr. Helinski's sort of bad behavior and all this, but I think it's pretty well laid out in my brief. Unless there are other questions for the court, I would rest on the brief.
Any other questions? All right. Then that concludes this argument. Thank you both.
Thank you.
Thank you, Your Honor.
We are live and on the record.
Good morning, everyone, and welcome to the May 13th sitting of the Massachusetts Appeals Court. My name is Mary Sullivan, and together with Justices Eric Nyman and Justice Catherine Hand, we will be your panel for today's appeal. The usual rules of oral argument will apply. Each side will get 15 minutes. There is no rebuttal. You can be assured that we have read your briefs with care, and we urge you to get to the heart of your argument. You're welcome to use your full time. If you find it unnecessary to do so, that's fine as well. For those of you who may be watching on YouTube, we hope there will be no technical issues. If there are, your screen may go momentarily dark. Rest assured, we will be back as soon as those issues are resolved. And finally, if you happen to see one of the judges look away from the screen momentarily, it's not a sign of inattention. You have our full attention. It's just that our briefs, transcripts, and other materials may be to one side of the screen or another. The next case is 20P0883, Costigan versus Association for the Recovery of Children and Others. Counsel, as soon as you see the timer, you may proceed.
Good morning, Your Honors, and may it please the court. Plaintiffs Rochelle and Mira Costigan brought this case, the underlying case, seeking damages arising out of physical and emotional abuse that we allege was inflicted on them by the defendants and appellee here, Mr. Kanyev, and what we allege is a vigilante group of paramilitary operatives who assisted Mr. Kanyev in removing Ms. Costigan's and Mr. Kanyev's child from her custody in 2017. In the process, my client, Rochelle Costigan's daughter, Mira, was wrongfully, falsely imprisoned, and they sustained emotional distress and harm. As the court knows from the record, the parties, Rochelle Costigan and Mr. Kanyev, are also involved in a probate court action where they're litigating the custody of their son and the related family type issues. It is a matter of public record that the probate case is currently mid-trial in Massachusetts probate court. Now, in the
Counsel,
Yes, Your
thank you for your forbearance. I do notice that this case is not impounded, but to the extent that there are minor children involved, let's continue to leave their names to one side.
Understood, Your Honor.
Okay, thank you.
Now,
So let me actually ask a preliminary question. There is a little bit of information missing on most every page of the complaint in the record appendix. Is it redacted, or did I just receive a bad copy?
I'm sorry, Your Honor. The version that I'm looking at, Your Honor, seems. I think I see what you are referring to.
Bottom of every page, it's cut off, and so I'm missing pieces of allegations. It's not a long complaint, but I just wanted to make sure that that was.
Your Honor, I do see that now. There may be a couple of lines missing here and there, and I apologize for that. I don't think that has.
No apology necessary. You're telling me it's not really material?
It's not going to have an impact on the appeal before the court.
Thank you. So with that in mind, let me get to a substantive question.
Yes, sir.
Are you arguing that anytime a defendant brings an abusive process claim as a counterclaim, that it's violative of the anti-SLAPP statute?
No, Your Honor. Certainly not arguing that, and that is not. Our argument is not that broad, and we would certainly concede there are circumstances where an abusive process counterclaim could lie. This is not one of those cases.
Well, that leads to this question, and this is with regard to the second prong of the anti-SLAPP test. And it's, what if the defendant counterclaimant files an abusive process claim because A, let's assume their argument is they know that the plaintiff's claims are false, and 2, therefore the only reason to make such baseless claims that the plaintiff would have would be to leverage or defame the defendant. If those two predicates I just said are met, would an abusive process claim be appropriate? Counterclaim.
I appreciate your question, Your Honor. It is a little bit difficult to answer that in the vacuum, because what does it mean for a claim to be false? For example, here, the counter plaintiff, the defendant, has not moved to dismiss the underlying complaint and has not alleged any facts, any actual facts to show that this complaint was brought in any way in order to gain leverage in other proceedings or to
well, he did file an affidavit, and he did attach orders from the probate and family court, which one could interpret to be inconsistent with some allegations in the complaint. So under such circumstances, what is a judge to do at the trial level? And I'm talking about the second prong. It's incredibly difficult to resolve that at this stage of the proceedings. And it seems to me that Judge Barry Smith, recognizing that, had to make something of a discretionary judgment call.
Well, and I think this goes to the motivation prong of the analysis, Your Honor. Essentially, Mr. Kanyev's affidavit lays out his beliefs and certainly claims some facts that are disputed, but that are his version of the facts that supports his beliefs for what the motivation was underlying this lawsuit. And the case law is well established in Massachusetts that the motivation, that a plaintiff's motivation in petitioning, behind the petitioning activity, is irrelevant. The motive behind the petitioning activity is irrelevant. The focus solely is the conduct complained of. And here, I want to be clear, Mr. Kanyev is not, we're not looking to preclude him from asserting counterclaims to the extent he can, which did barely survive a motion to dismiss. These are the other 5 counterclaims. He does have a defamation claim that's based on statements outside of the petitioning activity here. What we are concerned about is that he is looking to chill the petitioning activity of the mere existence of this lawsuit. Again, he has not moved to the extent that there was an argument that orders of the probate court were inconsistent with the allegations that are alleged in this case. Your Honor, I would have expected a motion to dismiss based on re judicata or collateral estoppel. None of that has happened here.
Well, we have under 12b-6, he has to accept the allegations in the complaint as true.
But to the extent there was a prior court order that would preclude the plaintiffs from bringing the claims here, he could have raised that, and he certainly did not.
So again, assume, well, I think this is in the record, that he denies several substantive allegations and says they are false. And as proof of the falsity, as evidence, he submitted affidavits and rulings from the probate and family court and other pleadings, which tend to suggest that some of the allegations in the complaint might not be true or are not true. Why, in that circumstance, is it inappropriate to deny a special motion to dismiss here?
Again, at this stage of the inquiry, Your Honor, the motive behind the petitioning activity is irrelevant.
This doesn't go to motive. He's saying they are false. Here is evidence that they are false. The allegation, so that's not speaking to the motivation, that's speaking to the substantive allegations. So can you help me out here? This is where I'm struggling with this. And in fairness to you, I struggle with this statute in a number of ways, as do many judges and practitioners.
And I think, Your Honor, it may be helpful to actually look at Mr. Kanyev's affidavit and focus on some of the statements in there. To the extent that the only statement in his affidavit, and this is on page 45 of the record appendix, it's an 8-paragraph affidavit. In the beginning, his name states that Mr. Kanyev and the plaintiff have a son, describes that there's an action in probate court initiated, and then goes through some history of the events that led to the removal of the minor child from Cambodia. Now, these are all statements that go to the dispute about the underlying subject matter of the lawsuit. There is not a fact alleged here, I would submit, Your Honor, that actually supports an abuse of process claim. Right? There's a distinction between Mr. Kanyev having a right to defend himself from substantive allegations levied against him by the plaintiff. There's certainly no issue with that. But it is really paragraph 8 that goes to the heart of the abuse of process claim. And really, and I respectfully submit, is the only statement that is relevant, which says, I believe that Rochelle and her daughter filed a present lawsuit against me to attempt to pressure me into making concessions in the custody case to ruin my reputation and to ultimately get more unwarranted money from me. So the only statement that I have discerned from this affidavit that goes to the abuse of process claim, Your Honor, is this belief as to the motivation. Well, this is a tort case. The plaintiffs certainly are looking for money damages. That is the nature of tort litigation. And again, this is why I keep coming back, Your Honor, to the motivation here. I mean, Mr. Kanyev certainly submitted this affidavit describing, at least in part, his version of the story and describing some of the prior litigation activity. To the extent that, and I do focus on the actual counterclaim, Your Honor. The actual counterclaim is fairly straightforward and simple. It's three paragraphs incorporating prior paragraphs and claiming that the plaintiffs brought their complaint in bad faith and for the ulterior or illegitimate purposes of extorting money from Kanyev. This is not enough to state an abuse of process claim to begin with, and this type of a claim is certainly on its face a hornbook example of an effort to chill plaintiffs' right to petition the judicial system for relief.
How does a judge make that determination as to whether or not the motivation in filing the counterclaim, the abuse of process counterclaim, is to chill petitioning activity?
Well,
and is that a discretionary determination?
Your Honor, here, I mean, the court certainly has discretion in interpreting the pleadings, but it's simply a matter of looking at the face of the pleadings here. I mean, this isn't the case where, like, for example, one of the most recent cases in Massachusetts, the Blanchard decision, where the court really did, in several courts, through multiple appeals, struggled with determining whether a newspaper article published by a hospital administrator was petitioning activity or actionable defamatory activity. Here, we don't have that level of, there's nothing to parse through here. Here we have a very simple fact pattern. The plaintiff brought a complaint seeking tort damages. The claims are false imprisonment, and intentional infliction of emotional distress, and conspiracy. And in response, the defendant filed a counterclaim that on its face is solely predicated on the filing of the lawsuit. There is nothing else here that suggests that there is any other basis for count 6 other than the mere fact of filing the complaint, and that is prohibited under Rule 56H.
But how does the judge, you still haven't really answered my question, which is, how does a judge make that determination as to whether or not the counterclaim is designed solely to chill the petitioning activity of the plaintiff? I mean, here he would say these allegations are false, they're defamatory, they're inconsistent with what the probate and family court has already determined. I didn't do this, and here's why it's being done. So how the judge has to make a determination. Why is what I just said insufficient for the judge to say, at this stage, I can't say that this was not done, that this was done primarily to chill petitioning activity?
Well, Your Honor, I think the distinction is between the abuse of process claim and affirmative defenses or denying and defending himself in the underlying lawsuit. And that's where the difference is. Mr. Kanyev is entitled to defend himself and to submit whatever evidence he has that he is not liable for the acts that the plaintiffs claim he is liable on. But that does not entitle him to sue the plaintiff for petitioning the court for relief. I mean, that is precisely the conduct that Section 56H is designed to prevent. And to answer your question, how does a judge determine that? The court looks at the pleading, and we were surprised, frankly, that the court found that the petitioning, that the count 6 could be based on anything other than the petitioning activity, where on its face, I mean, Mr. Kanyev does not try to cloak his count 6.
It can be right, but it can be based, the second prong, it can be based on the petitioning activity, but it has to be designed to chill it, primarily designed to chill it.
And this is precisely what the counterclaim is trying to do. It is asserting, it is trying to seek damages from my client for suing him. And that is exactly what the counterclaim is designed to do here. It's designed to pressure my client into not maintaining this lawsuit. Otherwise, abusive process claims, and I very quickly want to turn the court's attention to a couple of old 100-year-old cases that Mr. Kanyev has cited in the brief, which I think are instructive. There, litigants actually use process to obtain attachments and to use process to prevent folks from doing real estate transactions. That is a colorable abusive process claim. That is what the abusive process claim is designed to protect, not lawsuits.
Thank you, counsel.
Thank you. Thank you.
Does the panel have any further questions?
No.
All right. Attorney Cole. Your timer's up.
May it please the court, your honors, Michael Cole for the appellee, Nicholas Kanyev. And if I may, your honors, I'd like to start where my brother left off to address a couple of questions and some outside of the record issues, but I will let the court know that the litigation here was stayed for quite a while there was jurisdictional discovery performed and jurisdictional motion practice. As your honors are aware, there are two co-defendants, Basil Boz and ARC. They were contesting personal jurisdiction. And if you look at the case docket, you'll see that there was an agreement to stay the litigation. And so until those issues were resolved, Mr. Kanyev has issued filing a motion to dismiss, which he is going to because he believes that the complaint is a sham and that the counts lack factual and legal basis. Now, I know that's outside the record unless you can look at the docket, but I wanted to address that statement, your honors. Second, I'd like to go to Justice Naiman's question. What does a judge do when we're in a very preliminary situation here to assess the intent in filing the counterclaim, the intent of whether or not it was meant to chill? And I think that the judge did two things. Your honors, he looked at the totality of the counterclaim. I know my brother wants to cabin Kanyev's complaint or his counterclaim just to the two paragraphs that are asserted in count 6, your honors, but that count incorporates the entirety of the counterclaim, paragraphs 1 through 47. So I think the judge, the motion judge, looked at those paragraphs in evaluating the motive, whether it was solely based on the petitioning activity, and then he applied the fair assurance standard, which the factors are outlined in Blanchard 2, I believe, your honors, and then most recently in this court's decision in Rosario versus Caring Bees Healthcare. And when he looked at all those factors, he found that he was fairly assured this was not a slap suit. Now, to address my brother's statements about the motive of Mr. Kanyev, he's not bringing this specific counterclaim, one among, I think, 7, to chill any petitioning activity. He's bringing this, among his other counterclaims, your honors, to seek redress for all of the misconduct alleged in counterclaim paragraphs 1 through 47. And there's a litany and a long tortured history between the parties that goes back that supports that abusive process, which only culminated in the sham extortionate complaint filed in 2018. It's not solely based. There is an other substantial basis. And now if I could just direct your honor's attention to the actual definition in Duracraft, the SJC defined a slap suit as a generally meritless suit brought by a large private interest to deter common citizens from exercising their political or legal rights or to punish them from doing so. This is not what Mr. Kanyev was seeking to do here. Now, I understand the context of that initial definition, and it has been expanded a little bit, but at the same time, slap suits against meritorious claims have been shrunken by the augmented Duracraft standard, which even if Mira and Rochelle satisfied their threshold showing, which Judge Barry found they did not, they still would be protected by the second prong under the augmented Duracraft standard, which states that the judge must be fairly assured that the complaint was brought primarily to chill, which it was not here.
And so if we defer, I can tell you, Your Honors, this, but if we defer right to the language in Judge Barry Smith's endorsements, Your Honor, he goes through the sequential application of the Duracraft framework and the augmented Duracraft framework, stating that it was not a SLAPP suit and was not based solely on plaintiff's petitioning activity, namely filing of this lawsuit, because defendants' abusive process allegations include conduct from the past that extends beyond the lawsuit. Further, in the second sequential prong, the judge found that the court has determined the defendant's counterclaim, whatever its eventual merits may be, is designed to press Mr. Kaniev's claims seeking redress and damages in response to the lawsuit, not designed to chill the plaintiff's petitioning activity. And so we need to see what in the record supports that to determine whether it's an abuse of discretion. And I submit the specific question before this court is, are the allegations in the counterclaim, paragraphs 88 through 46, taken in the light most favorable, are those sufficient to support Judge Barry Smith's application of the augmented Duracraft framework and the fair assurance standard? And they do. The complaint of conduct is much more than just the filing of the complaint in 2018. There's ample support in the record, and I'll just go number one, Mr. Kaniev's allegations, and that's appendix 24 through 27. There is Mr. Kaniev's affidavit, and there is also the basis for the counterclaim was highlighted to the motion judge by Attorney Beeman in the oral arguments, and I've included that in the record at supplemental appendix 26 through 27. So that complaint was a subsequent misuse of process in addition to the litany of factual allegations in the counterclaim, Your Honors.
Let me ask you this question. In assessing whether a counterclaim is designed primarily to chill petitioning activity, is a judge authorized to go beyond the complaint?
It's a tough situation to put the motion judge in, Your Honor, because the statute allows for the filing of affidavits. And so I couldn't find any case law that determined whether or not the judge had to take the allegations and the affidavits in the light most favorable. I submit he does, but the statute says that you're allowed to submit affidavits, and then you have to take the facts as alleged in the counterclaim in the light most favorable.
What is the best appellate case that discusses the appropriate considerations and standards as to this aspect of prong two? And by this aspect, I mean determining whether a counterclaim is designed to primarily chill legitimate petitioning activity.
I would probably say the Blanchard case, Your Honor.
One or two.
Blanchard, I think they both address the standard, Your Honor. 477 Harrison Avenue versus Jace, 483 Mass 514.
Do they get into the details of what a judge, I just read them, and do they get into the details of what a judge can and can't consider with respect to that specific factor?
I actually don't have an answer for that, Your Honors. I didn't look at those cases with an eye to that specific aspect.
I can say that the appeals court decision in Blanchard, at least one of the opinions, tried to deal with that, and the SJC did not take up the invitation.
So, thank you, Your Honors. I couldn't answer that question. And I would submit that what else would Judge Barry Smith have had under his consideration to make a decision here, because the anti-SLAPPs are, again, in the preliminary stages of litigation. So I think he reasonably relied on the counterclaim and the affidavit, and as well as he could take notice of Judge Donnelly's court orders, Your Honors. So on this record, we submit that the motion judge properly denied the special motion to dismiss under the Duracraft framework. The decision should be affirmed, and Mr. Kanieff should be awarded his fees and costs. I just don't feel that the argument that the court was limited to only consideration of 2 paragraphs and 1 pro forma paragraph incorporating the rest is a colorable argument, and we're asking for our fees and costs. And I will rest on our brief for the remainder, Your Honors.
All right. Any questions? Thank you both very much.
Thank you, Your Honors.
Thank you, Your Honors.
We are live and on the record.
Good afternoon, everyone, and welcome to the May 13th sitting of the Massachusetts Appeals Court. My name is Mary Sullivan, and your panel today will consist of me, Justice Eric Nyman, and Justice Catherine Hand. The usual rules of oral argument apply in this virtual setting. Each side will have 15 minutes in which to argue. There will be no rebuttal. You may assume that we are familiar with your briefs and the record, and we urge you to get to the heart of your argument. If we have any technical issues, we will do our best to resolve them expeditiously. We hope that you will have patience with us as we will have patience with you. For those of you who are watching on YouTube, the screen may go dark momentarily, but rest assured that we will be back. And if you see us looking to one side or another during the course of argument, we mean no disrespect. You do have our full attention. It's simply that we're referring to the briefs or appendices which are on our tablets. The final case for today is 20P0877, Joseph Fergata versus Commonwealth of Massachusetts. Attorney DeMaio, you may begin when you see the timer.
Good morning, Your Honors. May it please the court, Christopher DeMaio for Joseph Fergata. So this is a pretty straightforward and simple appeal. The issue is whether the SJC's decision in Commonwealth versus Fergata was on grounds which tended to establish the innocence of Mr. Fergata on the intimidation conviction that was reversed. We suggest the only logical, reasonable answer is yes, it did. If there had been one allegation by the complainant here that all Mr. Fergata did was yell at her and then take her phone, and there had been one count in the complaint for intimidation, and there had been one conviction, and it had gone up on appeal, and the SJC had reversed and ordered entry of judgment for Mr. Fergata, that clearly, under the Renaud case, would have been enough to establish 258D liability. The Commonwealth is arguing that because there was a remand, and because there's supposed to be other theories or other evidence on remand, that the analysis changes, but we'd submit that doesn't really make any sense. There's 258D contemplates there'll be a remand. It's right in the statute. If there's a remand and a retrial, by definition, there was enough evidence at the first trial to convict. That's double jeopardy law. That's constitutional law. And that's what happened in the cases the parties cite, Guzman and Drumgold, and there's remands for retrials because there's enough evidence. You might come up with some new exculpatory evidence. You might come up with something that undermines the Commonwealth's witness, but it's always free for the jury to believe it or not believe it. So that doesn't matter, we would suggest. What matters is, under the Irwin case and the Peterson case, did the weight of the Commonwealth's evidence of a crime diminish? And clearly it did. The weight of evidence of a crime is just the sum of all the different evidences of alleged criminal acts. So if there's one alleged criminal act, somebody shot someone, and there's a couple witnesses, and there's forensic evidence, and there's consciousness of guilt or whatnot, and if some new evidence comes to light that detracts from that and reduces the weight, then that's one way that you might have 258D liability. If there's two theories, and if there's a theory, say you have a defendant who's driving under the influence and also driving over 0.08, then the weight of the evidence is just the sum of those two theories. And if it turns out the breathalyzer was bad and that theory is out, then clearly it reduced the weight of the evidence of the crime. Now, can they still on remand retry him for the other theory? Sure, but it reduced the weight, and I would submit, and I give.
Forgive me if this is an overly simplistic question, but let's do a hypothetical. If your client had been retried and found guilty of witness intimidation, would we be here?
No.
All right. So given that, and I take your point about the Drumgold case, but if I recall correctly, that was an acquittal, right? On retrial.
I don't recall if it was an acquittal or a null pros, actually.
Okay. And I don't necessarily recall either, but anything short of an acquittal or a null pros, an innocent suit could not be brought. So just because it wasn't retried, are we not permitted to look at the fact that the SJC articulated 3 different theories under which the defendant could have been convicted of witness intimidation?
I guess I'm not sure I understand the question. Are you allowed to look? I mean, certainly the SJC said that there were 3 different theories, but because there was a null pros in this case, went on remand. The only issue for this, the only issue really for Judge Donatel was the SJC case on grounds which tended to establish his innocence. Now,
yeah, and the SJC says we think he could have been found guilty on 3 different theories. So how does that establish innocence?
It establishes his innocence because they ruled out the one theory, and not just one theory. They ruled out really the only good theory that the Commonwealth presented, which is that he yelled at her and then he took her phone. They said, as a matter of law, that fails. As I said at the beginning, if that had been the only theory, clearly that would be the end of the matter. There would be 258D liability. The fact that they couldn't rule out a couple other theories does not. That just shows that there needs to be a remand. It doesn't show that it didn't tend to establish his innocence. It ruled out one entire theory of liability, just as in the breathalyzer case. If it were established that a breathalyzer were defective, you wouldn't say, well, they could still retry you and show you were under the influence. They could, but they're going to have a harder case. They're going to have a harder time establishing that you're in fact guilty, because it's been established conclusively that you're not guilty of one alleged criminal act, driving above 0.08, or Mr. Fragata's.
But that does not mean the fact that one theory was discounted. Why does that mean that tends to show actual innocence? We don't divide up a criminal complaint into separate pieces. We don't say intimidation of a witness theory A, or intimidation of a witness theory B, or intimidation of a witness theory C. The defendant is charged with intimidation of a witness, and in this case, the SJC, in attempting to protect the rights of the defendant because it didn't know what basis the jury's verdict was founded upon, gave the defendant the benefit of the doubt and said, retry it.
The complaint is not divided up. If this had actually been tried in the manner the SJC contemplated, it would have been divided up because you would need a unanimity instruction. But no one was in fact actually contemplating this at the time of trial. The theory was exactly what the prosecutor said, which is he took her phone after he yelled at her. I guess I don't really have much more to say than what I already said. If the criminal liability is you did some criminal acts, and if they allege you did 2 different things, you yelled and you choked her and you beat her up, or you drove under the influence and above 0.08, if you establish that one of those is not the case, you have reduced the weight of the evidence of guilt. It doesn't make it impossible to prove the case. You have reduced the Commonwealth's evidence of a criminal act occurring. And that's all that you have to prove. This is a preliminary motion to dismiss stage. He ultimately has to go into court and prove by a preponderance of the evidence. I didn't do any of this stuff at the end of the day, but all he has to prove now is that the SJC reversed his intimidation conviction on grounds and the phrase is detracted from the weight of the Commonwealth's evidence. That's from Peterson. I just don't know how you can say it didn't do that. All the Commonwealth was left with was he choked her and he beat her up, which the first jury had rejected. And I've kind of bracketed and put in a footnote the issue that I don't know how they would have retried this if they had tried, because I think there's collateral estoppel, but never mind that. The point is, one theory, and I would just say the best theory, is no longer viable. Just quickly, the Commonwealth, those are the main points I wanted to make.
You agree that that collateral estoppel issue isn't in front of us, right?
I agree that you don't have to go there to decide this case.
Or that even that we should.
Yeah.
The SJC left it open, so.
Yeah, it's my I probably should have moved for a rehearing on that, but I didn't. But I don't think it matters for this case. I think all that matters is assuming I can assume that if somehow they could have retried him and on some alternate theory, the fact that the main theory was eliminated certainly went to the weight of the evidence. Just like in the drunk driving case, if he didn't seem all that impaired, but he was impaired enough to meet the Lattimore standard. But the really good theory was the breathalyzer, but it turns out the breathalyzer was no good. It was miscalibrated or whatnot. I would submit in that case too, if there was a null pros or an acquittal, that would show that would reduce the weight of the evidence, and it would tend to show it would be consistent with, it would tend to show the innocence of the crime charged. This is not a case like Riley. I'll just briefly, both sides cite Riley. That's a case where some evidence of guilt came in that shouldn't have. It should have been excluded because it was I think, a brutal violation. It was testimony by a co-conspirator. This is not a case where evidence of guilt accidentally came in. This is the opposite of evidence of guilt. The prosecutor specifically invited the jury to convict on these grounds that he had yelled at the complainant and called her names and taken her phone. Defense counsel did not object. The judge did not object. So any reasonable jury might have done just exactly what this jury did here. So I don't see how this case is not really governed by Riley. And the same goes for the Irwin case. The Irwin case, as I understand the Irwin case, they have kind of an objective standard of the evidence. So in Irwin, the evidence was irrelevant. And I think what Justice Lenk is saying is if you have irrelevant evidence, inflammatory arguments by a prosecutor, inflammatory photos, it doesn't really affect the evidence one way or the other. It doesn't affect the weight of the evidence objectively. But because jurors are emotional and whatnot, they'll get a new trial. But that's not what 258D is about. 258D is about objectively important information. And she gives an example of a police officer committing perjury. That's extra information that the jury shouldn't hear, but it could also be consistent with 258D. So I would submit this is totally objectively reasonable. Hearing the prosecutor invite the jury to convict on these grounds it was very reasonable. It's not really like Riley or Irwin. It wasn't evidence of, this isn't like any kind of a technicality. It wasn't a hearsay or any sort of technical evidence that should have been suppressed. So the case is distinguishable. It's a little bit different than all the cases I acknowledge, but it's based on the principles that I've just argued. I would submit that Mr. Fragata should get to have his day in court.
Okay. Thank you.
Thank you.
Any questions? All right then, Attorney Rose. You are muted, Attorney Rose, and we need your timer.
Thank you, Your Honor.
There you go.
Good afternoon, Your Honors. May it please the court, my name is Nicholas Rose, and I represent the Commonwealth of Massachusetts in this matter. As my brother points out, the only real issue in this case is the SJC's decision overturning Fragata's conviction and whether it's on grounds that tend to prove his innocence. We submit that the Superior Court correctly determined that this conviction was not overturned on grounds probative of the proposition that he did not commit that crime, because the SJC repeatedly stated in that decision that there was sufficient evidence to convict Fragata of witness intimidation, but that it couldn't determine whether the jury convicted on this evidence or on the theory that the prosecutor advanced in his closing, which was legally deficient. So while that ambiguity was sufficient to overturn the conviction, it did not demonstrate his innocence of the crime, especially in light of the SJC statements that there was sufficient evidence to convict him on other grounds. I think our brief lays out a number of our arguments, so I wanted to sort of address some of the arguments that my brother has made in his oral argument, and of course, answer any questions that the court may have. In his briefs and his oral arguments, my brother focuses on that we supposedly focus on the remand fact. It's not the nature of the relief that's the issue here. It's the why of the relief. So it's not that the case was remanded, it's why it was remanded. And here, the SJC in remanding, number one, continued to make all the statements that there was sufficient evidence to convict on this alternate theory. It's also noticeable that the SJC's overturning did not deprive the prosecution from using any of this evidence that it had already found sufficient in a retrial. So the prosecution wasn't barred from using any evidence, and it wasn't compelled to admit any new evidence. So there wasn't, especially that might be exculpatory evidence. And that's what happens in Drumgold and Guzman, which my brother repeatedly cites. There, you've got explicitly exculpatory evidence that had been improperly withheld and that went directly to, was entirely probative of the matter, i.e. the identification. In Drumgold, he had an alibi, and in Guzman, he said it was someone else. And in both cases, the exculpatory evidence went to the heart of the matter and thus went to innocence. Here, the SJC has said the opposite. It said, look, there's sufficient evidence of witness intimidation. We just don't know whether the jury convicted on that grounds or on the prosecutor's theory. And nothing about that decision changed the evidence that would happen at a retrial. And so that distinguishes it.
What do we do about the fact that the jury acquitted on the assault and the strangulation counts, which the facts of which feature so prominently in the SJC's discussion of possible bases for retrial?
They do, Your Honor. I guess I'd make 2 points. The first is the SJC was obviously aware that the jury acquitted on those grounds and still said there was sufficient evidence to find of witness intimidation. And, we said that repeatedly, even acknowledging that he was acquitted on other charges. And I submit that's because we're talking about different standards. And the SJC went out of its way to note this in multiple places. So you've got some specific standards that the prosecutor would have had to meet for strangulation, for kidnapping, for assault and battery with a deadly weapon, and for assault on a household member. But the SJC made very clear that for witness intimidation, there doesn't have to be a proven criminal violation. There just has to be a possible criminal violation. And so whether it turns out that the prosecution could prove that beyond a reasonable doubt doesn't negate the crime of witness intimidation. And the SJC laid out all the reasons why it thought that was true. And we don't know exactly why they didn't find, maybe they didn't buy the deadly weapon part of assault and battery with the deadly weapon, or maybe for the assault on a household member, maybe prosecution didn't prove that there was a sufficient dating relationship to qualify under that part of the statute. There's a number of specific requirements that had to be met for those crimes that don't have to be met for witness intimidation. And I think the SJC laid that out in their decision. They went through that and were very careful to point out that you didn't have the same standards and that all you needed was a possible criminal violation and that the investigation didn't even have to start yet. And then it laid out why it thought there was still witness intimidation. And it did that numerous times. And that decision is the focus here. So I think that's the most important thing to look at. I'll also note that I believe my brother is overstating or understating the burden he has to meet here. It's not simply affecting the weight. Both the Guzman and the Irwin courts are very careful to say, and they take this language directly from the statute. They say it had overturned on grounds probative of the proposition that he did not commit the crime. So as Your Honor noted, we don't divide up witness intimidation. The question is it probative of the proposition that he did not commit witness intimidation? And they borrow that language from 258 D1C6, which is referenced in 1B, where they use that specific language. And this is consistent sort of with the legislature's intent to restrict the claimants who are eligible for this. There's a number of requirements. You have to have been sentenced to prison for at least a year. You have to be not guilty of any other related felony or any lesser felony. They're clearly going for this probative of the proposition that you did not commit the crime. And I don't think that happened here. And in fact, the Riley court, which my brother mentioned, specifically says that it's not enough to make it, and the quote here is, the court's ruling only made it more difficult for the Commonwealth to prove that he did commit the crimes by excluding additional inadmissible evidence of guilt. So it's not enough that you make it harder for the Commonwealth to prove it on retry. It has to be probative of innocence here. And that's why I think it's, even if the facts are a little bit different, as my brother argues, this is more of a legal issue rather than a admissible of evidence. The rulings in Riley and Irwin go to the situation here where you don't have exculpatory evidence that was taken away. And we think Riley and Irwin are directly comparable here, where the court excluded some evidence that may have influenced the jury. So in Riley, they excluded two co-defendants' confessions. And that, as the court admitted, probably made it harder for the Commonwealth to retry, but it wasn't probative of his innocence. And that's the same here, where you've got the evidence that the SJC has found is sufficient is still there. That's not been affected by the ruling. I believe our other arguments are laid out in our brief. I'm happy to answer more questions, but otherwise I'm happy to rest on the briefs.
Seeing none, thank you both very much. That concludes our arguments for today. I'd like to thank everyone in the clerk's office and our IT department, our law clerks and interns, and everyone who has made this sitting possible. We wish you all the best for a happy and healthy summer, and we hope to see you in person in September.
Thank you.